TPA we had planned. Today, the session that is scheduled for today, we will be discussing appeals under GST. We have our very learned speaker Jatin Harjai sir from Jaipur with us today. He will throw his insights on the nitty-gritties of appeals as to what one has to take care while filing appeals, important points to check, and of course, the issues, the litigations going on in all over the country, I would say, with regards to the appeals being filed and appeals being rejected by appellate authority on certain technical grounds. I would also request Jatin sir to throw some light on whether the appellate authorities, maybe the first appeal authority or the tribunal in that case, has the powers to condone any delay on account of delay in filing of appeal. And what happens if an SSC is going to the writ court and seeking such condonation of delay? And we have seen writ courts in certain cases have allowed subject to deposit of certain costs, but how much, whether that can always be taken as a plea by SSCs or not. So various factors, tribunal is not there, but yes, we have seen in the latest council meeting that there is a positive direction towards the tribunal being formed, and the central GST, the CGST authorities are of the view that the amendments proposed in the Finance Act will be in place from 1st of August this year, so that we can have the benches created by next of this early of the next year. We can have the benches ready and we can start having hearings at the tribunal also. So with this background, I again welcome Jatin sir to our platform. Everybody knows Jatin sir, so
thank you very much.
I will not give you a very detailed formal introduction of sir. We are very happy to have you with us, and we would be enlightened in the next after half an hour, after we discuss of the basic provisions of appeal. We request you to take we will update you, sir, when we need to start your session. You need to start. But as I stated in the earlier, certain fine points that as audience we would of course like to hear from you is the precautions to be taken care while filing appeal. Also, because the appellate tribunal is not there as of now, so what an SSC should do in order to see whether one has to go to the writ court or not, and your experiences with the honorable writ courts as well as the appellate authorities. And of course, the law says something, yes, order should be a detailed order, it should contain facts and everything. But what we have seen over the times that it is being rejected, the appeals are being rejected on frivolous and technical grounds also. So your take on it, those, sir. So with this, we welcome Jatin sir. I, being the chairman of the DTPA's indirect tax committee myself, so I have taken this occasion to welcome you, sir. And it is my good luck that I would be taking the first part of the half an hour of this session along with you, so that wherein I would be just taking up the legal provisions for the audience to have a fair view of what are the appellate provisions, and I'll just touch upon certain disputes also, which of course Jatin sir will take up in the second half of the session, and we'll have the query answer session at the end of the day. So with this, we have our Shyam Agarwal ji is there, who is representing DTPA, and I am the chairman of the indirect tax committee. So we welcome all the participants again. Today being a Saturday, we are not having the physical session at the DTPA hall, because that hall is in the income tax building, and we don't get permission to have it physically on income tax building on weekends. But because of the dates and everything, we thought we will continue with the webinar board only in the total session. So now I would like to start the deliberation as regards the various provisions of the appeal under GST, which I would like to start with 107. Everybody of us has the Bare Act. There is no presentation for this today. We will just we will have the provisions with us. Everybody who had joined earlier physically also were supplied Bare Act from DTPA. So kindly have your Bare Acts with you, and I'll take you through some of the provisions. We will start with section 107 of the CGST Act, and then we will go to the rules and see what are the appeal provisions. So to start with, the first 107 of the CGST Act, it says appeals to appellate authority. So before appeals, we already have seen in the classes of assessments and audits, there after an audit has happened or a scrutiny of return has happened, a show cause notice has been issued, and that show cause notice in DRC1 has been adjudicated by the department, and the department has passed a final adjudication order in DRC7. So against that order, if it's an order which is not in our favor, what recourse do we have? Our recourse is that we have to file an appeal before the first appellate authority. So I would just like to make a small distinction here between what used to happen in the erstwhile regime under the service tax and excise and what is the appeal provision under the GST regime. So as all of us knows, in the service tax and excise regime, if the order was passed by the commissioner as an adjudicating authority when the demand was more than 2 CR, then the appeal would have directly lied to the appellate tribunal, which was the SESTAT in the service tax and the excise erstwhile regime. But in the GST regime, the fun part is that commissioner is not empowered to adjudicate. The adjudication powers are only vested starting from superintendent up to additional commissioner and joint commissioner. The commissioner at any cost cannot adjudicate. So therefore, in this regime, if an order is passed by a rank of an officer starting from a superintendent, ranging up to additional commissioner, all the appeals will first have to go to the first appellate authority, and after the first appellate authority, the appeals should lie before the tribunal. There is no case, no situation under the GST enactment that the appeal can directly lie to the tribunal. It has to go to the first appellate authority under 107, and after the first appellate authority, it can go to the GST 80, which is being formed in due course. So this is a slight distinction under the erstwhile regime and this GST regime, which I wanted to point out for the audience at large. Coming to another aspect of appeals under GST, at commissioner appeal level in the CGST, see, I am keeping my discussion restricted to CGST. Why? Because every state has their own certain rules. Every state has their own formation of officers, the rank of officers, like somebody senior JC appeal, JC appeals. But we are keeping our discussion for betterment only with respect to CGST, so that it is universal all over India and we can have a threadbare discussion on it. Coming to CGST, if the order or adjudication order is passed by an officer up to the rank of superintendent, from the rank of superintendent to assistant commissioner or deputy commissioner, the appeal lies under 107 before the joint commissioner appeals or the additional commissioner appeals. So this is a new creature of the statute. When you compare this with the erstwhile excise regime, the service tax regime, there was only one appellate authority, which was the commissioner appeals. Under the GST regime, under the CGST provisions, the enactment, orders passed by superintendent or assistant deputy commissioner will lie before the additional commissioner or joint commissioner appeals. And order passed by additional commissioner or joint commissioner as adjudicating authority, the appeal should lie to commissioner appeals. So a very slight distinction is made. In appeal, in the first appeal also, the statute has created two different bodies. One being the commissioner appeals, hearing matters arising from adjudication order passed by additional or joint commissioner of level officers, and another being the joint commissioner or additional commissioner appeals, hearing matters passed by superintendent or assistant deputy commissioner as an adjudicant. So in the first appeal also, we have two wings of the first appellate authority, I would say, wherein the appeal would lie, and against the orders passed by both the appellate authorities, means the joint commissioner appeals or the commissioner appeals, the appeal would lie to GST 80. So it is only the department has carved out another portion on the same commissioner appeal level, just so as to segregate the orders passed between different officers. So suppose if I speak about West Bengal, so today we have appeals 1 and appeal 2 commissionerate in Kolkata, which is covering entire West Bengal, Andaman, Nicobar and various northeast territories. And West Bengal, I would say. So in appeal 1 also, we will have one commissioner appeal 1, commissioner appeal 2. Similarly, additional commissioner 1, additional commissioner 2, joint commissioner appeal 1, joint commissioner appeal 2. So what happens? Earlier there is only one person in that post. Today there are 3 persons for the same post. So the work can be bifurcated. Commissioner appeal is not burdened with all the adjudication orders which goes in the appeal authority, and it is being divided amicably between various other departmental offices. So this I just wanted to point out two very basic changes, a difference in the erstwhile excise service tax regime vis-a-vis the GST enactment, the CGST enactment, to be very specific. Now coming to section 107 directly. So 107 says any person aggrieved by any decision or order passed under this act by an adjudicating authority may appeal to such appellate authority as may prescribe within 3 months from the date on which the said decision or order is communicated. Now I stop here. So again, a comparison with the old erstwhile regime, it was 60 days. In GST regime, it is 3 months. So again, I would request Jatin sir to throw some light on this aspect also as to what is the difference between days and months. Because many times appeals are rejected on this ground that there is a delay of 2 days, and you have not produced substantial evidence to condone that delay. So there is a difference between 3 months and there is a difference between 60 days. As per 107, the due date is you have to file an appeal within 3 months from the date of communication. Now, communication, all of us knows today the communication is in the portal. If the adjudication order is in the portal, that day will be deemed to the date of communication. You cannot take a plea that I didn't logged into my portal, I didn't receive any email, I didn't receive a speed post. Not required, sir. Valid mode of service. Valid mode of service, if you see section 100 and
you must be talking about 169.
169, sir. Yes, 169. Service of notice in certain circumstances. So it says that GST portal service on the GST portal is a valid service. So you need not require an email or a speed post to come to you of the order, and then you will count your 3 months from that day. So 3 months from the date when such decision order is communicated, you have to file an appeal before the first appellate authority under section 107. Now, what are the basic requirements when I go to appeal? The basic requirement for the appeal to get admitted is pre-deposit. Like under the erstwhile excise service tax regime, the pre-deposit was 7.5% of the disputed tax or penalty. In the GST regime, for the first appellate authority, it is entire amount of the accepted tax liability, including interest penalty, and 10% of the disputed tax liability. So say an adjudication order was passed wherein a demand of 2 lakh rupees was raised along with interest and penalty. Out of the 2 lakhs, 1 lakh rupees I have agreed. I know I have to pay. I do not want to litigate on it. So for the balance 1 lakh for which I want to exercise my appellate remedy under 107. For filing that, first I have to pay 100% of my accepted liability, which is 1 lakh plus the interest and penalty on the 1 lakh, and 10% of the disputed liability, which is 10% of 1 lakh, which is 10,000. If I pay this, then only my appeal gets admitted. Otherwise, my appeal will not be admitted. My appeal will be rejected on the ground of non-compliance of provisions of 107. It is written under section 107 subsection 6. No appeal shall be filed under subsection 1 unless the appellant has paid in full such part of demand amount of tax, interest, fine, fee, penalty arising from the impugned order as is admitted by him, and a sum equal to 10% of the remaining amount of tax in dispute arising from the said order, subject to a maximum of 25 crores in relation to such appeal as this. So maximum pre-deposit can be 25 plus 25, 50 crores. Subject to 10% of the disputed demand, disputed tax. So here I would just like to throw one point. Recently in Calcutta High Court, what had happened, an SSC had approached the Honorable Writ Court on the ground that the tribunal was not there. The Writ Court entertained the petition but stated, no, you have to pay 20% of the disputed tax, a disputed demand. So the word used in the order was disputed demand. So when it comes to demand, it would include tax, interest, penalty, fee, fine, anything which is confirmed. But what is used in 107 per se is 10% of the remaining amount of tax in dispute only. So that matter went before the division bench in intra-court appeal, and division bench clarified that 10% is to be paid for of the tax, not of the entire demand, because the statute itself says it is 10 disputed tax. Though writ court under Article 226 can give any sort of directions, it is not binding. This act provisions may not bind the writ court. But on a plain reading, when the law is very clear, therefore the intra-court appeal also stated it should be read as 10% or 20% of the disputed tax in question. I would just like to throw one important point which we faced in one of our cases, wherein the tax demand was 4 crores. We paid the demand to the extent of 3 crores 99 lakh 75,000. 25,000 demand we disputed. Interest department invoked interest on the entire amount of 4 crores. I went to first appeal. I had to pre-deposit only 10% of 25,000. And the entire amount of tax which was already paid during adjudication, it was appropriated. My question in this case is, if I have already paid 3 crore 99 lakh 75,000 only tax, I have not paid interest on it, because I had my reasons that this interest is not payable. Can the appellate authority admit my appeal if I only pay 10% of 25,000 rupees, or I have to pay the interest also of the 3 crore 99 lakh 75,000 which was already paid? Kindly understand my question. Law says in full such part of the amount of tax, interest, fine, fee, penalty arising from the impugned order as is admitted by him, and 10% of the disputed tax. So if I have admitted 399.75, 3 crore 99 lakh 75,000, then I have to pay the interest on that amount also, and then only my appeal can be admitted. So how to save yourself from these situations? So in such circumstances, what we did, we showed that the entire amount of 4 crore is disputed. Though we had paid 399.75, it was appropriated in the order, but we were disputing entire amount. Otherwise, for 25,000, because I had to litigate that interest only. I was not interested in litigating that 25,000 of tax. That was a small amount for me. But my point of litigation was that I need not pay interest on 399.75 because I had a running balance with me throughout. But the department had confirmed interest on that amount also. So, pre-deposit, there is no provision of interest. You need not deposit any amount when you are filing an appeal. Under the interest head, no deposit is required. But the problem arises that if for the same adjudication order, some part is accepted, some part you are disputing, then for the part accepted, you have to pay the interest also. Then only your appeal gets admitted. So please be very careful in such circumstances wherein the entire order is not being challenged, a part of the demand is only being challenged. If the part which is not being challenged, the appellate authority would tell you, no, sahab, aap pura pay kar aiye, otherwise it is non-compliance of 1076. So this is one of the finer points which we faced in one of our cases, and then how we did in our case, which I have already told you. Then 1077 is very important. It says where the appellant has paid the amount under subsection 6, recovery proceeding for balance amount shall be deemed to be stayed. A very important provision. 10% they be there, department fir aakar bank attach kar le, where is the law? Then what is the use of paying 10%? So law says, law is an embedded provision in the act that okay, if you pay 10% as per 1076, if you make the pre-deposit, no recovery will be done for the balance. So a very welcome provision. Then 1078, the appellate authority shall give an opportunity. So opportunity of hearing is there. It is given in 75 also, general provisions relating to determination of tax. You cannot be, appeal order cannot be passed without giving you the hearing, and that's a basic principle of natural justice. As regards adjournment, it says no adjournment shall be granted more than 3 times to a party. So if sometimes a date has come, you are not available, your advocate is not, your consultant is not available, you take a date. So you can take a date for maximum 3 adjournments you can take. 3 adjournment ले सकते हैं, मतलब चौथे में प्रेजेंट रहना है, तीसरे में ही आपको प्रेजेंट रहना है, ऐसा नहीं है, 3 बार आप एडजर्नमेंट सीक कर सकते हैं. दिस इज व्हाट द लॉ सेज. Now I come to 10711. This is one of the very disputed provisions in my view, of course. In old regime, what we have seen, that though in the service tax and excise, there was no specific provision of remand by the appellate authority to the adjudicating authority. But basis a decision of the Honorable Gujarat High Court, the appellate authorities were quoting the judgment and remanding the matters back to the adjudicating authority. If at all it was something, say a computational case or a demand was based on certain figures which the appellate authority didn't have the access to. So it was remanded back to the appellate by the appellate authority. Now, what does 10711 in case of CGST Act says? I am reading it from the Act. The appellate authority shall, after making such further inquiry as may be necessary. These mark these words. I will have certain objections on these words. Pass such order as it thinks just and proper. Now, confirming means the demand gets confirmed. Modifying, 100 confirm, 100 का demand था, 98 कर दिया गया. Annulling the decision, 100 का demand था, 0 कर दिया गया. Or order appeal against, but shall not refer the case back to the adjudicating authority that passed the said decision on order. So, भाई साहब, क्या हुआ सर? 10711 में तो specifically बोल दिया गया है कि the appellate authority shall not, is not may not, shall not refer the case back to the adjudicating authority that passed the said decision on order. मतलब the powers of the appellate authority has been curtailed by the enactment already, has been curtailed by the enactment, and it says that appellate authorities, भाई साहब आप amend कर दो, आप कम कर दो, आप बेसी कर दो. Modifying का मतलब कम नहीं होता साहब, modify मतलब बेसी भी हो सकता है. But आप remand नहीं कर सकते, and this is one of the very welcome steps I would say, because especially in our East Zone in Calcutta, what we had seen during the last 2-3 years, 40-50% of the matters were being remanded back. Will be remanded back. Citing High Court's Gujarat judgment कि the appellate authority has powers, so it was remanded back. So समझिए, the appeal of 2014 came to be heard in say 2019. Period was say 10, 11, 11, 12. And again, I go back to that period of 2014 after fighting for 8-9 years. In this way, justice cannot be delivered in my humble view. But because this provision, I don't know whether it would be litigated in near future or not, whether the appellate authority, because today when we read Supreme Court judgments and various other judgments, what is coming out that the court does not want to enter into the domain of the judiciary, of the legislature. Legislature has made the law, it has to be followed as it is, unless it is in gross violation of the provisions of the Constitution or any other relevant provisions. Now, provision to 10711 says, provided that an order enhancing any fee or penalty or fine in lieu of confiscation or confiscation goods of greater value or reducing the amount of refund or ITC shall not be passed unless the appellant has been given a reasonable opportunity of showing cause against the proposed order. Means if the appellate authority wants to increase the demand, decrease the refund, then he has to give you a reasonable opportunity before passing the order to put forth your comments on this particular point. And then the second provision says, provided further, where the appellate authority is of the opinion that any tax has not been paid or short paid annually refunded, or where ITC has been wrongly availed or utilized, no order requiring the appellant to pay such tax or input credit shall be passed unless the appellant is given notice to show cause against the proposed order and the order is passed within the time limit under 73. Here lies the confusion. Appellate authority has been given powers to act as an adjudicating authority, I would say. It says, where the appellate authority is of the opinion that any tax has not been paid. So during the appeal proceedings, he comes out with an opinion or he brings certain materials on record to see that, okay, bhai Ankit Kanodia, आपने तो मेरे हिसाब से आपने ये tax pay नहीं किया है. But adjudication order में that has not been confirmed or that has not been demanded. Then it says the appellate authority can raise that issue also, but the appellant has to be put to show cause notice. My question is, who would issue this show cause notice? The question which I have is, who would issue this show cause notice and who will pass this demand order? Or will the appellate authority itself give me a show cause notice? Ki, okay, under proceeding number A, I have come to know that you have not paid tax in this period. Therefore, I am issuing you a show cause under 73 or 74. You come and give me a reply and I will take it as a part of the main appeal order. What does the law want to say in this? I am not sure. Of course, we'll have Jatin sir's views on this. Next, 10712, the order of the appellate authority disposing the appeal shall be in writing and shall state the points for determination, the decision and the reasons for such decision. Sir, padhne mein bahut badhiya hai. Such nicely worded phrase. Points for determination, decision thereon, reasons of such decision. But unfortunately, every time we do not see it in the face of the order. That is how the law is. Again, you can say this is a violation of natural justice. It is. Law is mandated the London Commissioner Appeal to follow these particular provision. But generally, we don't see these things happening in black and white. Then it says the appellate authority where it is possible to do. So, hear and decide every appeal within a period of 1 year from the date on which it is filed. Wherever it is possible, sir, not binding. Easy log hai. 1 year tak kar dijiye. Agar 1 year se zyada lage, to koi tension nahi hai. Upper limit nahi diya gaya. There is no upper limit. In fact, I still remember one of my cases last year. We had filed commissioner appeals. It was a refund matter in 2018. 22 commissioner appeals didn't call us for hearing. We went to High Court under Article 226, asking the High Court to give a direction to the Commissioner Appeals to pass an order within 3 months. Then the Commissioner Appeal took up the file and passed an order as per the direction of the High Court. Though it was against me, but of course, at least my next course of action to the tribunal opened up. No, otherwise it was just a refund matter for say 4 crores, 5 crores. Being stuck for 5 years, there is no value of that refund to the company. So, 107, very simple, very crystal clear provisions. But certain anomalies which we say is that no remand power, specifically written, but power to issue show cause, whether appellate authority can issue you a show cause. Now coming to certain procedural aspects of 107, which we'll get in Rule 108. For section 107, the relevant rule is 108, wherein the forms and the details as to the procedure to be filed has been given. So 108, rule 1081 says you have to file it within in form APL01, and you have to give the grounds and statement of facts as it was there prevalent in the earlier regime also. Now important is 1083, which has been amended from 26/12/2022. It is very important amendment in my view. It says where I am reading the amended provision, where the decision or order appealed against is uploaded on the common portal, a final acknowledgement indicating the appeal number shall be issued in form APL2 by the appellate authority or an officer authorized by him in his behalf, and the date of issue of provisional acknowledgement shall be considered as the date of filing of appeal. I file an appeal on the online in the portal. My DRC7 demand order was already there in the portal. I downloaded it. I uploaded it with the appeal, my appeal also, with my statement of facts, appeals, grounds of appeal. I uploaded the impugned order also. The appellate authority is required to issue an acknowledgement in APL2. So it says, if you have already uploaded that order with your filing, then the date of issue of the provisional acknowledgement, the provisional acknowledgement was issued on the day you had filed the appeal in the portal. There was an ARN generated, and that was the date of provisional acknowledgement. So it says that it will be deemed that you had filed the appeal on that day only, on your date of uploading and filing it in the common portal. But where the decision or order appealed is not uploaded on the common portal, the appellant shall submit a self-certified copy of the said order within a period of 7 days from the date of filing of APL1. So I filed appeal APL1 online. However, I didn't attach the adjudication order or the impugned order. Then I have to submit the self-certified copy of the impugned order within 7 days of filing of my APL1, and the date and a final acknowledgement indicating the appeal number shall be issued in form APL2 by the appellate authority, and the date of issue of provisional acknowledgement shall be considered as the date of filing of appeal. So if I submit the self-certified copy of the impugned order within 7 days, my date of filing appeal is the date of my online uploading. However, if I miss this 7 days, if I had not uploaded the order copy in the portal and I do not submit it within the 7 days, then the day on which I submit this self-certified copy of the impugned order, that day will be the deemed to be the date of filing my appeal. So for the purposes of limitation, please note, for the purpose of limitation, it is very important that the date of filing of appeal, because 90 days is to be calculated from the date of impugned communication of the order, and your date of filing of appeal, if you are uploading the order impugned in the portal, it is the day of uploading it only. Because the provision prior to 26/12/22 was that in each and every case you have to do it within 7 days. And if you do not do it within 7 days, then your date of filing the hard copy would be deemed to be the date of filing of appeal. And many cases, in fact, we from West Bengal, I can tell you, Calcutta, many cases were rejected by the appellate authority on this ground. Recently, in one of the cases in High Court, we put up this point, and the learned High Court, the Honorable High Court, quashed the appellate order by stating that it is a very hyper-technical view has been adopted by the learned Commissioner Appeals. And the order was quashed and the matter was remanded for fresh hearing by the appellate authority on merits without going into the limitation. Just because I had uploaded online, but hard copy I have filed, say, after 3 months. Then, of course, there are procedural things also. When he will pass APL3, APL4, I'm not going into all those details. As regards appellate tribunal, it has not yet been formed, but yes, we have now the composition and the rules for the appointment of members as per the latest GST Council meeting also. The Maharashtra Chief Secretary has been given the mandate of the Search and Selection Committee, and maybe in due course by the end of this year we'll see tribunal going live. So I'm not going into those provisions also because those will not be relevant for today's discussion unless that is set in. And finally, under the statute, we can go to High Court and Supreme Court also. But today, what SSCs are going to High Court or Supreme Court is under Article 226. As there is no tribunal, there is no alternate remedy. Therefore, the courts have been burdened with this GST litigations, and courts are entertaining them on case-to-case basis under Article 226 of the Constitution. So, I have taken you through the basic provisions of appellate authority. There are n number of nitty-gritties, I believe, as to into the procedural part also, as to how many copies of appeal, because still today we don't have the appeal rules. The rules that we just dealt with, Rule 108, is a procedure. But in the erstwhile regime, there was Central Excise Commissioner appeal rules, sestet procedural rules. So the procedure was specified through the rules. At least in GST, still now we don't have any appeal rules. We only have the form and the manner of filing the appeal, but there is no particular as to how much rupee court fees has to be paid, and all those things are still not prescribed in the statute. I will just like to touch one more provision before we hand over the session to Jatin sir for his deliberations and the issues. Section 120, appeals not to be filed in certain cases. Or section 121, sorry, I'll take 121 first. Non-appealable decisions and orders. Notwithstanding anything contrary to the provisions of Act, no appeal shall lie against any decision or order passed by an officer of central tax if such order or decision passed relates to any one or more of the following matters, namely, an order of the commissioner or any authority empowered to direct transfer of proceeding from one officer to another officer. Non-appealable order. Ankit Kanodia was doing the assessment, वो पास होकर Mr. ABCD के पास चला गया, you cannot appeal against it. An order pertaining to seizure or retention of books, register and documents, either search and seizure, this 67, 68, कुछ भी होता है, वहां पर आप retention आपका books लिया जाता है, पंचनामा बनती है, you cannot challenge those proceedings in appeal. An order sanctioning prosecution under the Act, if you are arrested for anything or any prosecution is lodged against you, it cannot be. And lastly, it says an order passed under section 80 of the Act, which is installment scheme, payment of tax under installment. So there was a doubt also when the law was new that whether appeals under 129, provisions of 129 appeals can be made or not. It was the various high courts had taken a decision also that yes, appealable 129 orders are appealable orders. And one more point which I just missed was, I told you the pre-deposit under 107 was 10% after the total admitted tax. In case of 129, it is 25% of the penalty. Section 129 is a provision for 200% penalty in case of violation of provisions of e-way bill and everything. Against that also, if you prefer an appeal against the detention order after the release is done, then you have to pay 25% of the penalty in order to file the appeal. But if you have already paid 200% of the penalty and got the goods released and then you go to appeal, no further pre-deposit is required. Similarly, tribunal, as I told, not yet formed, but we'll see I think by early next year, we'll have the tribunal being formed. There is already a removal of difficulty order passed by the CBIC, wherein they have stated that unless the tribunal is formed, the appellant cannot be prejudiced. Prejudiced in the sense no recovery can be made. But here again, there is a litigation. After the appeal order, if you are not going to High Court, the department is starting recovery proceeding. You go to High Court is entertaining subject to 20% deposit. In recently one of our cases in Calcutta High Court, the first step, the single bench, learned honorable single bench ordered us to pay 20% of the disputed tax and then recovery would be stayed. We challenged that order before the honorable division bench, and division bench had deleted the part of 20%, had admitted the appeal without any condition of reimbursement. Such orders have been passed, but various other high courts like Patna High Court, Odisha High Court, Telangana High Court have always taken a view that first you have to pay 20% and then only your cases will be done. So this was a basic overview of the entire provisions for appeal and the corresponding rules made there too for filing of appeals. Now I would request Jatin Harjai sir to take us through the nitty-gritties of filing appeals and of course the litigation surrounding appeals. Thank you very much. We will have the question answer session after Jatin sir's deliberation is over. Sir, over to you, sir.
Thank you, Ankit ji. First of all, thank you to the organization for having me here. It gives me an opportunity so that I can share some of my thoughts with all of you. And I must say, and thanks Ankit ji, he has very nicely taken us through the relevant provisions, or I would say key provisions, which are useful, and has tried to identify some of the issues, given some solutions as well. But please, friends, please keep it in mind that it's only 6 years that GST has been implemented. So 6 years is a very short span of time for development of any tax law. No one can expect, or I would say no one should expect, that everything will get settled within such short span of time. Indeed, it takes much longer time. Things like issues in appeals, specific clauses are just started. And to be very honest, I had a couple of disagreement with what Ankit ji said. I might be wrong, but I will try to put up my case in those specific aspects. So, and we never know that who is correct, who is wrong. Maybe whatever we have discussed or whatever we are going to discuss tomorrow or at some later point of time from Honorable Supreme Court, we get to know some third thing. So the bottom line is we must study the legal provisions directly and try to interpret in light of judicial pronouncements. Before I come up for specific questions which were posed before me or I have in my mind, I just would like to remind everyone some basic fundamentals. That is the most important. I'm sure each and everyone is well aware with Article 265, which says, no tax shall be levied or collected except by authority of law. I must mention, this is what one of the very important aspect, very important provision in our constitution, through which we can derive our litigation strategy. Whenever you received any show cause notice from that level till the highest forum, whenever there are important facts are there, one has to frame up a strategy. Just for an example, today only I got a email from one of the client. What is tax rate on this one, this particular thing? My specific answer was, and in fact, we have already given the written opinion to them on this aspect, that in our opinion, the tax rate is 28%. Thereafter, they said, okay, now we have received the show cause notice on this and this, that you have paid 18%. Instead that the correct rate should have been 28%. One simple answer to this could be that, okay, now you paid 28% because in my opinion also the tax rate is 28%. But my answer was not this. My answer was whether this show cause notice will stand in before the courts or not. We will tell you after going through with the show cause only. Not just that I am having an opinion 28% tax rate is there. Show cause is also saying 28% tax rate. It does not mean that proceedings initiated by the authority are as anticipated in law. And if the proceedings initiated, if the collection mechanism initiated by the authority is not as per law, they are violative of Article 265 and cannot stand. Those cannot stand in the eyes of law, and quite possible they will fall down when in the hierarchy. So most important aspect one should keep in mind that all these mechanisms of collection must be in accordance with law. If there is any deficiency, the proceedings are at nullity. I will take you through some of the examples as well. The moment comes. Just to cite couple of judgments on this. One may refer judgment of Honorable Supreme Court in case of Hukum Chand Shamlal. It says that it is settled that when an authority is required to exercise a power in a certain way, then it should exercise the power in that manner only and not at all. All other modes of performance are necessarily forbidden. किसी और manner में कर ही नहीं सकते, other than the law, other than by the way which law prescribes. If they do so, in that case, it will be treated as violation of principles of natural justice. Key aspect. On the similar line, there was another judgment in case of Babu Varghese. Again, Honorable Supreme Court has specifically said it is a basic principle long settled that when law provides a manner of doing a particular act in a particular manner, then that act should be done. Then that act must be done in that manner or not at all. They have referred to a couple of English judgments and given thrust on this aspect. Moving ahead, one may refer judgment of Honorable Supreme Court in case of Oil and Natural Gas Corporation of India. In that case, Honorable Supreme Court identified three key aspects of legal policy of India. That whenever there is any pronouncements are to be made, whenever any judicial or quasi-judicial exercise is to be done, then all court authorities, judicial or quasi-judicial, are supposed to adhere minimum these three aspects. Number one, judicial approach. Now, what is judicial approach is a very comprehensive thing. Fairness is at the rock bottom. So, one aspect is judicial approach. Another aspect is principles of natural justice. What is the principles of natural justice? How it is to be done? I'll take you through in a maybe in a greater deep how they are useful for us in appeals. And the third principle is reasonableness. So these are the three key principles with which each and every court, authority, judicial or quasi-judicial, must adhere to. With this background, now let me take up a couple of issues which is being identified by Ankit ji, or some of things which I have in my mind that I should discuss with you while I'm deliberating upon all this particular aspect, how one should take handle the appeals under the GST regime. I heard partly, Ankit ji, is it possible, Ankit ji, for you that whenever we are discussing something, you take this relevant statutory provision on the screen for the benefit of all.
So Ankit sir is in a call. He will be back in some time and he'll address you.
Can anyone else do that thing?
Sir, what do you want? I'll just share the screen accordingly.
You may just open CGST Act with you.
Okay.
And while having CGST Act, maybe whatever provision I am discussing, you may
Okay.
display it on the
I'll
screen
go
for
to
the
that
benefit of all.
section. I'll go to that provision and share the screen accordingly.
That will be great. So one aspect which Ankit ji was dealing, that in GST law, the assessment or adjudication cannot be done by the commissioner. I have some different opinion on this. You may refer section 5 on in this regard. Section 5, subsection 2 is there, which is unique in this GST law. It's like, that the police mechanism is being incorporated under this law, which specifically says that you may open that section 5, subsection 2, section 5. Powers of any officer can exercise powers which are being entrusted to his subordinate. This is what has been specifically incorporated under the GST law. 5. Yes. Just a moment. Please read this. An officer of the central tax may exercise the power and discharge the duties conferred or imposed under this act on any other officer of the central tax who is subordinate to him. This is what happened in the police powers, that every senior officer can exercise whatever powers are assigned to him or to his senior subordinates. So similar powers are there. So in my considered view, there is no bar in taking up an adjudication by the commissioner or additional commissioner or joint commissioner. If they want, they can take up those assignments which are assigned to maybe superintendent, maybe assistant, maybe joint. They can do so. But there will be a challenge. If commissioner does this exercise, commissioner exercises this power, we will be facing another problem. Because GST law expect the appeal to be filed to the first appeal will be to the commissioner only. It cannot be directly to the appellate tribunal. Now, the problem, if commissioner exercises this kind of power, then the problem will come that the commissioner has passed the order of adjudication and the appeal cannot be filed at the same with the same rank officer. So that will be again a situation which will create a complex situation, answer of which is not available as on date in the statutory provisions. It may come at us at some later point of time whenever government gets to know that this kind of anomaly has been created. Now, let us go one by one on some of the aspect. See, many a time, whenever we are going through with a particular case, you have received a particular case for filing of the appeal, or you have just got an order in original with you, and you are examining whether we should file appeal or not. Let me give you an example. Then frame up your mind. Let's say there is a dispute on a particular product. For example, flywheels. Flywheels which are being used in a automobile industry. There is a dispute going on that whether this flywheel is chargeable to tax at the rate of 28% or 18%. This is what a dispute as of now. A particular company is paying GST at the rate of 18%. Now, department searched the premises, and at the time of search, the statement of that person, owner or a director, was recorded, and they admitted, yes, the flywheel is chargeable to tax at the rate of 28%. They've given this kind of a statement. And on the basis of that, the show cause notice was issued. An order is passed. in order adjudicating authority specifically says that since the director or the promoter has himself agreed, accepted that the tax rate on this particular item is 28%. Accordingly, order is passed. Now the question is for you, can you file the appeal, or will you advise the client to file the appeal that no, tax rate on this is 18%? When the client has already admitted that yes, tax rate is 28%. On the contrary, there may be a different situation. Maybe some ITC, the investigation was going on, let's say on taxpayer section 70 summon was there. When the summon, in pursuance of the summon, statement was getting recorded, and the person admitted that these so and so ITC cannot be, yes, should not be allowed. Because see, nowadays the new development is you are going through with the statement, officer show, read it and then give the answer. Let us assume this. It is absolutely illegal in my opinion, the way of taking a statement. But let us assume that it has happened. Assessee agreed, assessee accepted that, okay, so and so ITC I have, let's say for example, uniform of the employees, GST paid on uniform, on purchase of uniform of the employees. Assessee admitted, yes, it was not, we were not all eligible, but we have claimed the credit. So there is an admission to the fact. Now, is it worthy to file the appeal in this scenario or not? Please mind, and one may note a legal principle here, that there cannot be any estoppel against the law. There cannot be any estoppel against the law. Tax rate on a particular supply of goods or services has to be decided as per the legal principles, as per what the law says, as per the respective notification, using the interpretative tools, using the judgments, not by someone says so, not by assessees admitting. कल को assessee कहता नहीं इसके ऊपर 5% है, क्या डिपार्टमेंट मान लेगा उसको? So judicial decision cannot be based on someone is admitting something or someone is agreeing to do something. So please mind, this is a principle, well-established principle, that there cannot be any estoppel against the law. If someone wants to refer, one may refer the judgment, very famous judgment of Tata Chemicals Limited. This is a judgment of the custom law, in which what happened, the custom inspector took some samples in a manner which was not prescribed in the law. So when matter went up to, in fact, tribunal gave the judgment in favor of the revenue, saying so that when the sample was taken, the assessee's representative was there and he has not objected to that. So that is why there is a kind of consent. The consent was there in the manner how the sample is to be taken. Now the question comes, same story. When law provides a provision that sample is to be taken in this manner, can standing of a person or a representative there, or consent even given by the person there, can validate the proceedings? Answer is no. So whatever is stated in the law, there cannot be any estoppel against that. One thing one should keep in mind very carefully. Whenever these things are there, that someone has admitted something, consented to something, it may be about factual aspect, not legal aspect. If it is something about factual aspect, you can go through that cross-examination route, which I may be discussing at a bit later point of time. Number two, couple of things which I'm just having in mind. I'm sharing it with you abruptly, one by one. Now, many a time the issue comes that nowadays I have seen that department, while making searches, they see so many documents. many a times they interpret the contract in a very interesting manner. Now, the question which are getting posed before us is, many a time what department does is they pick up a particular clause from an agreement. They just pick up a clause from an agreement, and on the basis of those particular clauses, they confirm the demand. For example, recently we have seen in one of the cases, the clause written was that GST shall be paid in addition to the consideration. That kind of a clause was there. So department made the case that their agreement is also saying or admitting that GST, this particular transaction is liable to GST. Now, in this regard, one must note, there is a lot difference between how an agreement is to be read and how a law is to be read. There is a lot difference into this. So I just wanted to identify or highlight this particular aspect with all my friends here. Please mind, while a law is going to be interpreted, each and every section, each and every word used in the section plays a crucial role. Each and every section plays a crucial role in determining or identifying what is the meaning of that particular clause. One may refer a superb judgment in case from the Honorable Supreme Court in case of Tara agencies, whereby Honorable Supreme Court goes one notch ahead, whereby they said, in case of interpretation of a statute, what has been said is important, and equally what has not been said is also important. They are equally important. What has been said and what has not been said. Can we say this aspect in case of interpretation of a contract? Answer is no, absolutely no. Contract has to be read in holistic manner. A particular word, a particular line, a particular phrase, if it is inconsistent with the other thing, in whole of the approach, what the particular agreement is trying to convey, so that has to be ignored. This is what how one should read an agreement. One may refer in this regard, very latest, the judgment of Honorable Supreme Court is the latest one, Nabha Power Limited. So in that case, Honorable Supreme Court identified some of the principles, what are the difference between how a contract is to be read and how a statute is to be read. So in case, primarily, 2 or 3 major pointers of differentiation and interpretation of the agreement and a statutory provision were, number 1, while examining a document or a contract, the intention or ascertainment in case of a contract or agreement interpretation is what is to be conveyed, what is intent or meaning behind that document, what that document want to convey. Whereas in case of a statutory provision, each and every section, each and every provision, what the provision want to convey. This is what a fundamental difference between the interpretation of an agreement and interpretation of a statutory provision. Number 2, many a time you have seen when a particular 2 parties are entering into a contract, so many kind of negotiations happen. That, okay, this is what offer, this is what qualified acceptance, then there is a counter offer, then there is acceptance, something. That this is a rate, this is with this, that negotiation, a final contract has been drafted. Similarly, in case of law, what happened? Discussion happens in law. Maybe at law committee level, maybe like in our GST, in GST council, maybe even before GST Council, in the law committee of the GST Council, maybe press release. So many things are there whereby these kind of discussions are available. Now, important is how much these discussions or negotiations are having binding impact or relevance. Please mind, in case of contract, all such negotiations are important. All such negotiations are important. Say something is not provided in the agreement, one can take it up from the negotiations. But in case of statutory provision, legal provision, please mind, if the statutory provisions is clear, if it is unambiguous, then whatever kind of discussion, debates prior to enactment of this provision has no relevance. Whenever we read that these kind of press release has happened, this is what the GST Council has discussed, this. Please mind, if statutory language is clear, it is unambiguous, those discussion debates has no relevance. They get only and only relevance when the provision is bit ambiguous. In that case, to understand the reasoning intent, one may refer to those other aspects. So this is what the basic difference, second difference between these two. Third and the important point is, Honorable Supreme Court says that if detailed and synectical analysis of a word in a commercial contract is going to lead to a conclusion, that is against the business common sense. That has to be ignored and business common sense has to be prevailed. Whereas one read the statutory provisions and language of the statutory provision is clear. No logic comes in that. Uske raste mein koi dusra logic nahi hai. If the language is clear. Whereas it is not in the case of a contract. So this is what one more differentiation of the aspect. Coming to third point, yes, I think Ankit ji highlighted this. Condonation of delay. So now we have so many assessees, so many cases are being regularly received by us. That's okay, this happened, that happened, and we could not file appeal in time. I have one bad news for them, but for sure, so many good news for them as well. I'll tell you how to treat them. But on the front of condonation, in my humble opinion, please avoid seeking condonation and try to take other routes. I'll discuss why I'm saying so. Honorable Supreme Court, in their judgment, which if I'm not wrong, that's a constitutional bench judgment in case of New India Assurance Company versus Hilly Multipurpose Cold Storage. They have categorically, I would say, settled this preposition. They clearly said, if law provides provision for condonation, the authority does not have any right to condone the delay for filing of the appeal beyond the period prescribed in the law. For example, law says 3 months time period for filing of the appeal, 1 month for condonation of the delay. In this case, the appellate authority does not have any right to condone the delay beyond that. This is what has been cleared by the Honorable Supreme Court in a crystal clear terms. Moreover, please mind, even the recent development is the Honorable Supreme Court has advised that even High Court should be careful in admitting the cases in case of condonation. Many times you will go to High Court, you will see that 400 days condonation, 500 days condonation. Recently, I have seen in case of 1000 days condonation, you are explaining your justification. But please mind, the recent developments are, even the High Court should be very, very cautious. and should not entertain the matter just as an alternate to appeal. High Court should see this, whether the petition coming before them is just an alternate to the appeal, because appeal time has already been left. In that case, they should not entertain the petition. So this is what I always say, that one should avoid seeking condonation if the time period is expired. If your time period, whatever is prescribed in the statutory provision, 1 month, 45 days, if that time period is over, don't go for condonation, see some other route. We'll discuss what other route I'm suggesting. But one thing is true about condonation. Once you are within time limit of condonation, that's, let's say your 3 months are over, and now you are filing condonation application within 5 days, 7 days, 10 days, something, or within 30 days. Then all the judgments, I must say, support the view that condonation application must be dealt in leniently. That means normally court or authority should allow the condonation. Meaning thereby, entry into the condonation is strict within time frame. But once you entered in that time frame, it is lenient. One has to understand this provision in law of the condonation in this sense. Now let's move ahead on a bit different note, which I heard Ankit ji as well for a short span of time. I don't know whether I could heard completely. Service of the notices. Now see, before what, let's go ahead, how to serve. That's important. There are two different aspects, how and when. How any services are to happen on the under the GST regime of any notices or the orders. A very common issue which we are seeing is, I'm sure that all must be witnessing, that more than 50% times, the notices from the GST authority, more specifically from the central authorities, are being received either physically or through their email. They are not getting uploaded on the portal most of the time. Now, I would just refer you one of the judgment from the Honorable Madhya Pradesh High Court. That's Akash Garg versus the State of MP. In that judgment, Honorable Madhya Pradesh High Court has held that GST law provides, Rule 142 of the GST law provides that all notices and the order, when we are talking about notices in reference to Rule 142, we are talking about show cause notice. So show cause notice and order must be uploaded on the portal. I just request to the organizer, can you place Rule 142 on the screen?
Sir, I am just putting it.
No problem. So, Honorable Madhya Pradesh High Court, referring to Rule 142, in crystal clear term hold, they specifically said that there is no doubt that the statutory procedure prescribed for communication of show cause and order is by way of uploading on the portal. That's it. There is no other way prescribed. So one has to follow that way. This is what I am just giving you one of the example, what kind of judgment we are having from the different courts. Now we will examine the, maybe with all due respect to honorable courts, rationale behind those judgments. Honorable court has given these verdicts referring to only and only Rule 142. Now, please read this Rule 142 with me. 142(1) talks about show cause notice and 5 talks about order. Let's go ahead one by one. It says, the proper officer shall serve along with the notice in so and so, a summary thereof electronically. It uses the term electronically. Please have a careful reading. Section 142, subsection 1 talks about show cause notice. It says it has the show cause notices to be sent electronically. This is in front of you. Fine. Please go to clause 5 of rule 142. 142 sub rule 5. Yes, this is what about order. Now, this is what order in original. It says a summary of the order issued under section so and so shall be uploaded electronically. Kindly have a look. There is a difference in these two clauses. Clause 1 says कि electronically जाएगा. Summary thereof electronically. It doesn't talk about uploaded. It says serves electronically. If you read from the start, it says the proper officer shall serve. Then this clauses goes and then it says a summary thereof electronically. So service is to be done electronically. Fine. Whereas 142(5) is saying it has to be uploaded electronically. I'm sure that everyone can witness the difference between the language which has been used by rule 142. Fine. So whatever be the things are, but on the basis of this rule, Honorable High Court said that show cause notices and the order has to be uploaded on the common portal. There is no other way this can be served. I have with all due respect to Honorable Court, I have a difference of opinion here. Serve electronically may include email. Email is also electronic communication. Serve electronically is maybe email, maybe by portal. But uploading electronically necessarily involves uploading of the order on the portal. This is what my humble reading of rule 142. But now the problem is what Ankit ji discussed with us. Section 169. So can you please bring section 169 on the screen? Now see what section says. You mean to just section once? Right. Okay. You are more smarter than me. Yes. Please have a careful reading with me. It says section. Now earlier we referred rule. Section says any decision, order, summon, notice, or other communication. Whatever communications are there under the GST law, all kind of communications can be made. Whatever or rules made, shall be served by any one of the following method. ये जो जितनी भी चीजें बोली हैं हमने, चाहे वो order हो, चाहे notice हो, चाहे summon हो, whatever, they can serve either of these methods, and there are 6 methods which are provided: A, B, C, D, E, F. If I'll just touch upon what these methods are, clause A talks about giving or providing a physical copy or maybe a tendering. What use for this, tendering it directly to the assessee or their authorized representative. Please read it. Please have a look at this section very carefully. This is very important. And let me tell you, I'm sure that by reading this whole of this section 169, you'll agree with me कि आपके 90% cases जो आप सोच रहे थे time barred हो चुके हैं, वो time barring से बाहर आ जाएंगे. So now section 169 says order or notice can be served by either of these mode. First mode is physical tendering to the taxpayer himself, his authorized representative, something. Number 2 is through the registered post. Number 3 is by way of an email. Number 4 is uploading on the common portal. Number 5 is publication in a newspaper. Number 6 is affixing on a place of a last known place of the assessee, जिसको कि हमारे यहाँ local language में we call it as a चस्पा करना, clause F. So what this law says is 6th mode, that affixation at the place of the assessee is to be done as a last recourse when none of the 5 above can be worked out. So precisely first 5 are the important things. When these 5 doesn't work out, then only affixation comes into picture, and total 6 modes of services are there. Fine. Now there may be an argument that MP High Court, yes, while giving that judgment, has not discussed section 169. They have given verdict only and only on the basis of rule 142, and prima facie there is a conflict between rule 142 and 169. This is what the argument of the department in so many cases. That section will always prevail when there is a conflict. So section says yes, order can be given physically, email, uploading portal, etc., etc. Now, what is my answer in this? This is absolutely correct. That 169 provides 6 ways to serve an order or a notice. And government cannot plead that rule 142 again is ultra virus to section 169. They have formed it. Rule 142, in my humble opinion, is taking up a particular mode of service in case of serving of a show cause notice and order. In case of show cause notice, rule 142 is saying that, okay, you can send electronically, and electronically there are 2 methods, by way of email or by way of uploading on the common portal. In case of passing of the order, rule 142 is taking up only and only one of the method provided in the law, that is by way of uploading on the common portal. So please mind, if you have received an order which has not been uploaded on the common portal and sent to you otherwise than by way of uploading on common portal, maybe email, maybe hard copy or whatever. So in those cases, service has not completed in terms of 142 and your time limit is not started yet. Please mind it.
Sir,
so if this kind of issues are there, forget condonation because your time limit has not started. Yes. Now, someone wanted to ask some question.
I wanted to ask here one point.
Yes, please.
Sir, 142, as you correctly stated, it says the proper officer shall serve along with notice under this, a summary thereof electronically in the DRC1.
Correct.
So it is saying for the summary of DRC1 to be given electronically.
Very correct. Very correct.
But 169 being the parent section for service of any communication, it lists down 6 sections, 6 categories, as you rightly told.
Correct. Correct.
So if I receive a hard copy of the show cause notice without DRC1,
correct. Go ahead.
as was done in the erstwhile regime, I have received over speed post, but I have not received DRC1 till today.
Go ahead with your question.
So do I, in that case, whether I participate in the adjudicate proceedings or I just take this view?
I will cover your question after 30 minutes.
Sure.
When I'll be dealing principles of natural justice,
Sure.
I'll specifically cover this.
Thank you. Thank you.
Fine.
Thank you. Thank you.
As
Sorry
of
for
now,
the
what I am dealing with is what is service. Fine. So in this case, time limit for filing of the appeal shall be deemed to be started only and only from the date when the order is being uploaded on the portal along with DRC07. Fine. Now let us go to another situation. Now, most contentious situation which we receive is, sir, what happened? We have received the order on portal or an email, but our accountant was not there. Or we have not seen that order. Order was passed maybe in December 2022. We have accessed that order on today. I'm sure you must be facing this kind of problems. Maybe order was uploaded on the portal or sent through email in 2020 or 2021. Now the time limit for filing of the appeal is over. Let us assume that we take up the case of uploading on the portal only, because other than all other cases, I have already told you that the time frame for filing of the appeal doesn't start. Now, in this case, what's going to happen? Now, here I will, Ankit, I would like to differ from you. I don't know whether I'm correct or not, but I would like to differentiate from what you stated. If I'm not wrong, you stated that in case of online communications, that means when uploading on the portal or the email even, the date of uploading of the portal is the date of service. I humbly disagree with this. See, section 169 subsection 1, what we have just seen, provides us mode of services only. That what is the mode of service? It will be physical, it will be email, it will be a portal, it will be newspaper, something. Clause 1 does not refer what will be date of service. So date of service is something different and mode of service is something different. Please read carefully. It talks about mode of service in clause 1. Clause 2 and clause 3 of section 169 talks about date of service. Please read them carefully with me. I request all my friends here, please read it carefully. Clause 2 and clause 3 provides date of service of the order or that particular communication notice, whatever it is. Let's go it one word by one. Every decision, order, summon, notice, or any communication shall be deemed to have been served on the date. Please mind, now they are going to tell you the date. Hello, sorry, there was some call in between. Yes. Now this clause is going to tell you the date of service. Shall be deemed to have been served on the date on which it is tendered. Now, flow with me. Tendered. This is what? One of the mode. First mode, what was being provided in the statutory provision. Correct, na? Clause A was talking about it. Or published. The term published was used in clause E of section 161 for a newspaper. For when the copy is given to you, and or a copy thereof is affixed in the manner provided in subsection 1. So precisely speaking, section 169 subsection 2 is providing us date of service in 3 cases. Out of 6, in 3 cases, that 169(2) is providing date of service. And what is that date? On the date when it is physically tendered, on the date when it is published in the newspaper, on the date when it is affixed. Now let's go to clause 3. It says, when such order, decision, summon, notice, or any communication is sent by registered post or speed post, it shall be deemed to have been received by the addressee at the expiry of the period normally taken by such post. So date of service in case of registered post will be the normal time period. For example, if you are sending an order from Kolkata to Siliguri, let us say normal time period is 3 days. So whatever the date of dispatch plus 3 days will be date of service. If you received it actually a day before or a day after, doesn't make any difference. Law says whatever the reasonable time, we will deem it as it has been served. Now, I'm sure that all of you must have observed by now that 169 subsection 1 provides 6 mode of communications, whereas 169(2) and subsection 2 and subsection 3 provides date of service for 4 modes only. 2 modes are still there, for which date of service has not been provided by the law. What are those 2 modes? Number 1, email. Number 2, uploading on the common portal. Clause C and clause D. What about them? Law is silent. What would be the date of service? Whether the date of email or whether date of uploading on the common portal? My answer is no, none of them. the date of service of these orders will be the date when I have first accessed those orders on common portal, not before that. Let us assume the order has been uploaded on the common portal on 1st January 2023. And I have accessed this order on today, that is 15 July 2023. Then date of service of this order is 15 July 2023, not before that. Let's talk about legal rationale behind this. When I'm saying so, what is source of this particular view? Please mind, you must have heard about, or I'm sure you are well aware with the provisions of Information Technology Act 2000. One more aspect, before I tell you some provisions, whatever is there in the IT Act, Information Technology Act 2000, please mind, Section 81 of the Information Technology Act is having overriding effect on all provisions, on all other laws made in this country. Just like SEZ law, IBC law, PML law, all these are having the overriding effect to the other provisions. Similarly, IT Act is having a non-obstante clause towards all the prevailing acts in India. So if any inconsistent provision is there under the GST law from the IT Act, the provision of IT Act will prevail. Number one. Number two, as we have already discussed and identified, there is no provision in the GST law which tells us date of service in case of a electronic communication with email or uploading on the common portal. So there is no question of any inconsistency if IT law provides what is date of service. Correct na? Now let us go to IT law. There is a specific provision, section 13 in the Information Technology Act 2000, which deals with 4 aspects in any electronic communication. Number one, date of sending of the communication. Number two, place from where the electronic communication is sent. Number three, date of receipt of the electronic communication, date and time of receipt of the electronic communication. Number 4, place of receipt of electronic communication. These 4 aspects are being handled by the Information Technology Act. So we are concerned here with that third aspect which I discussed with you, that date and time of receipt of electronic communication. Clause 2 of the section 13 specifically provides this aspect. What is the time when an electronic communication is supposed to be treated as now it has been received? There are 2 clauses. When a person has identified a computer resource, designated a computer resource, which is not the case. And another is when a person has not designated computer resource. So law is very clearly says when a person has not designated a computer resource, in that case, when that document has been accessed, then it will be treated as it has been served to him. That means in a technical manner, other way it says when it enters into the computer resource of the recipient, then only it can be said that it is a date and time of receipt of the notice. So in my humble opinion, if your order was passed on 1st January 2023, uploaded on the common portal on 1st January 2023, but you have not opened the common portal since then, and you have opened that portal on today and access that notice on today or order on today, your time of service will start from today. Your 3 months will start from today. So this is what the other way which I told you that how to bypass that condonation route and use these particular provisions. that now date of service will start from here. Let me give you another third or fourth way out as well. See, I'm sure you must have gone through with so many notices when you receive it, or maybe receive through email or the common portal. You receive the notices maybe without signature. Many a time we receive the notices without signature, orders without signature. Can anyone by any stretch of imagination say that without signature is a valid document? अगर आपको फिजिकल मिला होता किसी पुराने जमाने में, तो क्या आप उसको वैलिड मानते? What has changed? Only a mode of communication. It doesn't mean that signature will not be there. Signature and stamping has to be there in the orders. So find out if you are having a scenario whereby order is there on the portal, but it doesn't bear any signature. It is null and void. So there is no question of even starting the time limit of 3 months for filing of the appeal. Next example. Many a time you will see that the order which has been uploaded is signed by a DSC, digital signature. Many times you must see that there will be a digital signature on that. And digital signature does not mean scanned signature. Please mind it. Now, you see what happened when signatures are there. We also do a signature for our clients in our so many communications. In my office, all my communication are through DSC. Even our agreements with our client, our invoicing, everything is through DSC. When you mark a DSC, आप उसको ध्यान से देखिए, observe it carefully, उसको थोड़ा enlarge करके. Many a time you will see there is a green tick mark. Many a time you will see there is a green tick mark on that particular DSC. That green tick mark, it is okay, verifiable. That signature is correct. But many a time you will also see that DSC is there, but there is a yellow question mark. A small question mark is there typed with that. Maybe you guys may just check on a Google. DSC or a digital signature having marking validity unknown or signature not verified. So many a time you will see that the order which has been passed by the authority is signed digitally, but there is one aspect is mentioned, validity unknown. Or maybe digital signature not verified. This kind of comment is there on the order, on the signature itself. You may enlarge the signature. Ankit ji, for the benefit of all, it will be great if you just type this thing on Google and show it to the maybe participant. Just type it on the Google. The digital signatures having marking of signature not verified. Second, you can search validity unknown. If this kind of markings are there, this is absolutely null and void order. There is no question of starting the time limitation. I hope you got it. You just see some images on it. Can I share my? Just type image. Click on image. DSC. No, not this one. आप ऊपर लिखिए. आपने क्या लिखा ऊपर? ऊपर देखिए, ऊपर आइए.
So this image would show.
Maybe this type of. Maybe this type. आपने ऊपर search में क्या लिखा है?
Sir, DSC having marking signature not verified.
और दूसरा भी लिखिए. Signature validity unknown. ये राइट साइड में जिस तरीके से आ रहा है. यस. सो अब देखिए, अब नीचे जो दिखा रहा है ना, एक नीचे बॉटम पर एक दिखा रहा है क्वेश्चन मार्क वाला. हाँ, ये सारे गलत है. दिस इज द ओनली वैलिड सिग्नेचर. ग्रीन टिक मार्क इज देयर. signature valid. So for what validity unknown, this is illegal. So please mind, I was just on that particular aspect. I have stressed it too much. So first of all, condonation. Try to see if it is within time frame. It is within time frame. You file it with some whatever genuine reason. There are multiple jurisprudence which you will find in your favor, which says it has to be held leniently. Number one. Number two. Then see if your 4 months are over. Then you see number one whether it was served on the portal or not. If it is not served on portal, there is no question of that there is a valid service. Chapter ends. You may request the authority to upload it on the portal in that case. Number three, let us assume it is uploaded on the portal. Check whether signatures are there or not. A DSC with digital signature. If it is a digital signature, then check whether these kind of deficiencies are there or not. If you want to maybe go through with some judgment on this, there is a direct judgment from the Honorable Bombay High Court in case of DBS Trade Link, from whereby Honorable Bombay High Court has discussed this aspect, that digital signature having validity unknown, not verified, is null and void order. The moment it is a null and void, there is no question of starting any time frame for the appeals. So all these aspects must be examined by all of us professionals. This is what I just wanted to add to it. Now let's go ahead on some another aspects. Coming to the next point which I have in my mind, that pre-deposit. See, pre-deposit aspect, Ankit ji has well covered it. I will just take you to some of the disputed issue into it. The biggest issue which arose was when you are going to file the appeal and going to pay pre-deposit, can you pay the pre-deposit amount through the electronic credit ledger or not? This was the biggest question. To start with, there was a negative judgment, I would say. Negative to the assessee, favorable to the revenue, by the Honorable Odisha High Court in case of Jyoti Construction, whereby Honorable Odisha High Court in crystal clear terms told that pre-deposit cannot be made through the electronic credit ledger. While saying so, they have examined the GST Act provision. Let us go through with those provisions. Ankit, we have CGST Act in front of us? Because once we frame any opinion, I think we should not frame any opinion just because what one court is saying or what another court is saying, because conflicting judgments are already there. So once we should be well aware with the logic why a particular court has taken a particular view. So please, let's start from section 49. 49 talks about output tax. Section 49, you can come directly to 49. Section 49 is payment of taxes, how a tax is to be paid. 49.3 talks about, yes. Now, 49.3 talks about how the electronic cash ledger is to be utilized. 4 talks about how the credit ledger is to be utilized. So if you'll go to cash ledger, from the cash ledger, you can make any payment towards tax, interest, penalty, fee, or any other amount, etc., etc. This is what is written in 49.3. When you come to 49.4, it talks about that the amount available in the ECL, electronic credit ledger, can be used, may be used for making any payment toward output tax. Please mind it. So there is no question of interest, penalty, fee as it is there, as the same is there in clause 3. So section 49 talks about that electronic credit ledger is to be used for making output tax. Now please go to section 2, subsection 82. What is output tax? That's critical, which was the 3-4 provisions are there. 2, subsection 82. It says output tax means a tax chargeable under this act on taxable supplies made by taxable person, but excludes the tax payable by him on the reverse charge basis. Please have a look at it. Yes. Output tax in relation to taxable person means tax chargeable under this act. Now, section 49 is saying that you need to utilize electronic credit ledger for output tax. And output tax is a tax chargeable under this act. So now question starts arising. When you are filing the appeal, are you going to say that this tax is actually payable under this law? That's the first question which arises. Now this issue gets a very big blow from section 41. If this act is older one, please open section 41. Section 41. I don't know if it is a new one or old one. Section 41. No, this is a new one. So do we have an older provision? Two clauses, section 41. Yeah, just a minute. Yes, this one. Just a minute. थोड़ा ऊपर आइए 41 में.
Sir, old one is in the italics.
Yes. So italic at the bottom we can see. Please have a look at clause 2. Old provision clause 2. The credit referred to in subsection 1 we are talking about the credit which we have taken, shall be utilized only for payment of self-assessed output tax. Now all issues gets resolved in favor of the revenue. If we'll go to that judgment of the Honorable Odisha High Court, Jyoti Construction, these were the key factors in analyzing this. So what section 41 used to say, now it is over. Section 41 used to say that credit balance shall be utilized in self-assessed output tax. So earlier there was a question only that are you assuming or is it as per order? But by this provision, it made clear that self-assessed output tax, that means a self-assessment you are making in your GSTR 3B, or maybe at some later point of time, the making payment through DRC 03. That is a self-assessed. So that amount for that amount only, electronic credit ledger could have used. This was the basis of judgment of Honorable Odisha High Court in case of Jyoti Construction. Now, this section 41 has been substituted by the new one, and the older provision is no more in the statutory books and it is not revised. By this, one can take a view that now statutory provision permits. Meanwhile, otherwise also, there are a couple of judgments even prior to this amendment, without going in this much of deep, has allowed use of electronic credit ledger in payment of taxes. One may note there is a beautiful judgment from the Honorable Delhi High Court, Amit Gupta versus DGGI. In that case also, it was allowed. Then there is a judgment from the Honorable Bombay High Court as well, OCS Reality, that has also allowed that the balance of electronic credit ledger can be used in payment of any pre-deposit amount. More importantly, there is a circular as well. If I'm not wrong, circular number 172, July 22 circular is there. That also gives a reasonable clarity to it that, okay, pre-deposit can be made through it. Though it doesn't use the term pre-deposit, but the way it has been explained, the intention is the same, that it can be used for credit ledger. One more issue which I found with relation to this pre-deposit, which, because we are discussing today mainly the this appeal aspect only, so maybe some issues can also be there. Question is, let us say there is a situation, a person does not have a requisite amount of deposit, but he has already having some refund which is yet to be received from the department. Can a person request the officer to get his amount of pre-deposit adjusted with this, maybe some refund which is due towards him? In my humble opinion, answer is absolutely yes. I owe some, department owes some amount towards me and I need to deposit. There is no reason that it should be denied. One may refer the judgment of Honorable Gujarat High Court in case of some Vinayak trade exim was there. If I'm not remembering the correct name, maybe somewhat different. But this was in identical situation under the Gujarat value added tax law. Gujarat High Court has specifically hold this. When there is a refund due towards the assessee and you want to make a pre-deposit payment, this amount can be adjusted out of it. So in that kind of situation, if you are having these pre-deposit issues, then I'm sure that you can do that. Next, if I go to the issues, a very another thing as well, which comes that many a time in GST, we've seen that during the inquiry proceeding, investigation proceedings, maybe search going on, some amount has been deposited under pressure. Assessee pays some amount through DRC 03 during the course of investigation before coming to the order, before order has been passed. Now, let us assume there is a 10 crore demand. Assessee has already paid 4 crore rupees. Now, the question is whether pre-deposit and assessee wants to challenge whole of that 10 crore rupees. Whether assessee is supposed to pay the amount once again. The remaining amount, maybe new fresh pre-deposit, 10% of the 10 crore. Or he is supposed to pay 10% of the 6 crore. Or nothing is to be paid. Answer is, in my humble opinion, no amount is supposed to be paid in this situation. Because the amount which he has already paid was under protest. He is contesting that amount. In this case, one cannot say that amount is being appropriated, has already been appropriated, cannot be said. And government, in fact, does not have any locus to hold that amount. In fact, government should return that amount to the assessee. If it is, even if it is not then done, then at least assessee has every right to get this amount set off from the pre-deposit amount. Now, there will be some procedural issues, undoubtedly, that because there is a on system their issue, one may have some struggle to it. Some ways outs are there by which the appeal is filed. You may file this kind of declaration along with the appeal that, okay, this amount is already there and accordingly some modify the amount in the pre-deposit column. You can do that. We have tried that and succeeded in it. In fact, if you want some kind of jurisprudence on this, yes, you can refer judgment of VVF India. That's Honorable Supreme Court judgment, which clearly hold this, that amount which was deposited prior to assessment can be adjusted with the pre-deposit requirement in this case. So if any amount is deposited prior to the passing of the assessment order, adjudication order, the pre-deposit requirement can be settled with that. This is what, in my humble opinion, one can use this. Then now the question is, can there be a way out by which the pre-deposit, without paying any pre-deposit, one can get his appeal entertained? In other words, is that pre-deposit provision is a mandatory or maybe against the rights of the litigant or rights of the any citizen, that he has some order is passed against him and competent authority is not having a power to pass a stay order until unless some particular amount is being deposited. So this thing can be addressed in two manners. Number one, whether the provisions of pre-deposit are statutorily valid, constitutionally valid or not. Answer is yes. It has been tested so many times, and Honorable Court has hold in most of the situations, rather in all the situations. Then in any provisions, statutory requirement of pre-deposit is valid, is not ultra-virus. Number one. This is what regarding validity of the provision. Now coming to the second aspect, on a case-to-case basis, on a fact-to-fact basis, the High Courts under Article 226 are having right to waive or reduce the pre-deposit amount but not in each and every case. In making out of an exceptional case, yes, the High Courts are having right to waive this pre-deposit itself. With this, coming to the one more aspect, which I think Ankit ji told me to discuss, that when a person can avail a writ remedy, please mind, Article 226 of the Constitution of India, in which the writs are being admitted, there is no restriction to it. Article 226 specifically talks about that writs can be entertained by the High Courts for enforcement of any of the right conferred by Part 3 of the Constitution of India, or for any other purpose. So it is not restricted to fundamental rights. For any other purpose, the writ can be filed, and it has to be it should be admitted by the honorable courts. Now, what is this any other purpose? Any other purpose means any of the statutory or the constitutional right of the taxpayer. If it is hampered, one may approach to the High Court. But what happens normally? Normally, High Courts has taken a stand, or you can say has made a self-made restriction. We would say it's not a constitutional restriction, though self-made condition, that while entertaining writ petition under Article 226, normally courts does not accept the writ petition if alternative remedy is there. Now, what is an alternative remedy? Alternative remedy means the remedy provided by the statute. In this particular case, in our GST, for example, an order has been passed. You have a remedy provided in the statute that you file an appeal under section 107. Please mind, there is no specific bar. There is no specific bar constitutionally or otherwise that High Court cannot entertain writ petition even if there is an alternate remedy. Number one. Number two, more importantly, it has been consistently held that in 4 specific situations, the High Court should not deny maintainability of writ petition. They should not deny even if alternate remedies are there. The 4 aspects they have discussed. This is what a celebrated judgment of Honorable Supreme Court in case of Whirlpool Corporation versus Registrar of Trademarks. In that case, Honorable Supreme Court has specifically held that in case number 1, there is a violation of fundamental rights of anyone. Number 2, there is a violation of principles of natural justice. Number 3, there is a challenge to virus. That means you are challenging the statutory provision itself. Number 4, there is a challenge to jurisdiction. In these 4 cases, one may directly approach to the High Court, even if there is an alternate remedy. Please mind, with this, what I am referring here is, if any of these 4 situations are there, one can directly go to High Court. But it doesn't mean if the case is not falling in this 4, the High Court cannot accept the writ. Even in that case, finding a suitable case, or more specifically, finding a suitable question of law, High Court can and should admit the writ petition, even if it is not falling in these 4. Now see, you can say this is an art of advocacy. You give me a particular case, or anyone a particular case, any lawyer, you will see by one way or another, the lawyers will make a case that they are falling in these 4 exceptions. That there is a violation of principles of natural justice, there is a violation of fundamental rights, there is a issue in relation to jurisdiction, that jurisdiction was not correct, there is an issue in relation to maybe some challenge to the virus is there. So believe me, in 99% cases, whenever someone is having this GST notice or orders are there, one can make a case that the case is going directly to writ petition. But normally I don't at this stage, whether one should advise go to High Court or not, this depends upon case to case. Now let us say order has validly served, just like we said, firstly uploaded on portal, valid signatures are there. Now you are finding it and you don't have the money to make pre-deposit. Now what's going to happen? You can try to, in this type of situation, you can try to directly go to High Court. Number 2, there's a harm as well to directly go to High Court, which one should be careful. See, in so many cases, in High Court, you win the cases on the ground of principles of natural justice. Or maybe the particular procedure has not been followed by the officer. Now, what's going to happen? Imagine a situation, there is an order passed by the authority. And in GST law, as on today, limitation for even 2017-18 is not expired. That was the first year of implementation of GST. So now what's going to happen? The moment the order is quashed, whatever the deficiency is there, the officer will remove those deficiencies and shall issue the fresh show cause, fresh order, whatever whatever be the cases. So in this case situation, quite possible, you have done good job, you have got a good decision from the court, but ultimately there is no relief to the client. Whereas if in the same situation, quite possible, if you would have gone through regular mechanism, that is first appeal. If not successful there, go to second appeal. If not successful, then go to High Court. Quite possible, believe me, in 99% cases, the time limit would have expired for initiating a fresh case. So these all strategies, whether you should directly go to High Court or not, is to be decided on case to case, fact to fact basis. There cannot be a straitjacket formula whereby you can decide, okay, no, yes, we have to go or we should not go. In these cases, we should go or we should not go, except one thing, that order is validly served and you don't have the money, then you don't have any option than to go to High Court. In that case, definitely Ankit ji is smiling. I can understand that. But all other cases, one has to examine whether real relief is to be received by the client or not. Ankit ji, what do you say? I have so many things in my mind which we can discuss. Would you like me to move ahead, or maybe we should open the floor for the Q&A, whatever you say?
So let us have some Q&A, because then being Saturday, you understand, no? So participant, we will have some Q&A, and the conclusion, then we'll again, you can, if we don't have a Q&A, we will have certain more aspects of your thought process.
Because I think I parked one of your question as well.
Sir.
Somewhere I told that when I'll be discussing principles of natural justice, then I'll be taking up, but I haven't yet reached there, because that's important criteria, that the principles of natural justice I can discuss for maybe couple of hours for them. If time permits, then I will maybe touch upon, or maybe some question and answer I will respond to them if required.
Shyam, we can have the question and answers. Regarding that time limit, sir, the point that I was discussing under Rule 108, That was when would after uploading the appeal in the portal, what will be the date deemed to be a appeal filed? That was the context.
So now I think that the rule is changed. Huh? The new rule says that
Sir,
you
now
need
the
not to
rule
file
says
the.
hard copy is not required to be filed.
Correct.
So the day you filed it is in the portal, that is the filing date. So we are discussing in that context.
Whatever you are uploading is the date of filing. Chapter
Yes, that was that
reason behind that is, please try to understand the reason and law behind that is, at no place GST law casts the burden to serve something on the officer.
correct.
We need to reply. We need to respond.
Correct.
So whenever it's towards assessee is supposed to respond from his side. See,
Yes.
communication has a two parameters. Now, one is from the sender side, another is from at the recipient side.
Correct.
So the moment at the end of the assessee, whenever we does our part, we have sent it. It's chapter over. Whether he read it or not doesn't make any difference, because law doesn't cast responsibility on us to serve something on the assessing officer. On the
Correct.
contrary, the law casts responsibility on the officer to serve something on us, because our time limit starts from the service at the recipient, at the assessee end. So that is why I discussed that Information Technology Act provision.
Yes.
Indeed, what I discussed, section 13 of the Information Technology Act, it is duly complied with. The moment you upload it, date of uploading is the date of communication from your side. We need not to check when the officer is going to read it or not, or whether he's reading at all or not. We need not to check it.
And in fact, sir, the 50th council meeting has also proposed that certain cases they will notify for manual filing, like 129 cases and everything.
I won't discuss anything until unless I have a notification.
No, sir. In fact, Odisha state government has already issued a notification prior to this council meeting that all the cases where temporary ID has been given, in Odisha state, you have to file appeal manually.
Have to, or it is an option?
Because they don't have the option to file electronically, that is why. It's a
Okay.
state notification.
Okay, so in that case, physical things are going on. Good.
Correct, sir.
Good.
In fact, in West Bengal, I would just appraise you, sir. In West Bengal, for 129 cases, they were giving the TRN, but it was not being. We were not able to file it online. Last 6 months, now they are giving the user ID password of TRN, and the 129 appeal is being filed online also.
Okay. So
Shall
here
we
we
get-
are filing
Yes.
online, not a problem. In fact,
Online.
129 cases are bizarre. If you handle it properly, there is not even a single case of the department which can stand.
Correct, sir. But they are on the ground of mens rea, sir. Whether it's a civil liability or not, don't know what will happen.
Or you can say the another violation of the principle of natural justice being nemo juris in causa sua, that the prosecutor cannot be the judge,
Yes.
whereas in each and every case of those
That is the same.
department, they are doing an investigation, they are themselves doing adjudication. How come they can survive?
Correct, sir. Video. Shyam, we can have questions.
I have given the permission to unmute. If somebody wants, they can unmute themselves or they can raise their hand. We can unmute them. If any of the participants are wishing to ask any question, they can just unmute and ask. Or they can put in the chat box. We'll read it out. Anybody having any question, they can raise their hand. Or I think let's keep it for the last if we don't have anything right now.
So I think people are already in Saturday mood.
Or sir, you have made it so crystal clear that people are not having any questions.
Oh, of course, sir. You have dealt it. You have taken each and every point very beautifully, sir. There's no point in that. Yes, questions generally in Calcutta still, sir. What is happening? Physical attendance is very difficult. We are still, people here are still like, okay, online to ho hi raha hai na. That is all.
Correct. So that's easy as well.
Review from a participant, that session was excellent and very gripping and interesting. So I guess this answers your query, sir. You have made it crystal clear to all the participants.
Thank you.
Thank you, sir.
Could we wind up?
Yes, sir. I think that would be, because it is 6 already, we can just wind it up. We'll just offer a vote of thanks, sir.
So I take this opportunity to give a formal vote of thanks.
I feel like people from among the home people, na Calcutta ke program. So no need to for any
Of
thanks.
course, sir, but just a small vote of right for your presence, just to note your presence.
Sir, for your deep gratitude for our Kolkata people, we'll like to give you a formal vote of thanks for taking out time from your busy schedule and deliberating on a very pertinent topic, which is important for all of us professionals, very, very importantly. So thank you so much for coming on the platform of DTPM and enriching all our members with your good advices. I'd also like to thank all the participants who came on a Saturday evening to attend this webinar and and grace the occasion. Thank you so much, everyone, and have a great weekend ahead. Thank you.
Thank you. Thank
Thank you,
you
sir.
very
Thank
much
you
for
very much.
each and every one of you for patient hearing. Thank you, Ankit ji, Shyam ji, for hosting it, for giving me this opportunity. Thank you.
Thank you,
Thank
sir.
you,
Our
sir.
pleasure.
Thank
Thank
you.
you.